tenants have repair problems often in their house or apartment. The problem is landlords often do not want to fix those things quickly or properly because it may cost them a lot of money. Tenants, though, need to know their rights so they know how they can encourage a landlord to make these repairs properly and well. The first thing a tenant should do is make sure their rent is paid. A tenant has very, very few rights, and they certainly are not entitled to have anything fixed in an apartment or a home that they're renting if they're behind on the rent. So the first rule is do not withhold your rent, pay it on time. Secondly, a tenant should give notice. Most tenants, of course, call. But the better plan is to send a letter clearly in writing and date it and send it certified mail. That sends a message to a landlord that you're serious. Secondly, state law says if you send the letter by certified mail, you only have to send it once. You don't have to send more than one notice. If you don't send the notice certified mail, you have to send two in most cases. Now, after you've paid your rent and you sent the landlord a notice or two, then you should wait a reasonable time. A reasonable time is an amount of time that depends on the nature of the problem. If it's a sewage backup, then a reasonable time may be a few hours or a day. If it's something more less significant, it might be a roof repair, a landlord might have a week or two before they even consider responding to give the landlord an opportunity to get bids from contractors in order to re-roof the house or apartment. So a reasonable time varies with the kind of problem it is and the effects that it's having on the tenant. Now, that brings us to the type of problems a tenant has rights to have repaired. State law says that a tenant is entitled to have a repair if the problem materially affects the health and safety of an ordinary tenant. And let me say this again, it has to be affecting the health and safety of an ordinary tenant, not necessarily the actual tenant living there, you. It has to be the health and safety of some ordinary person that would be living there. The other thing to remember is it has to materially affect health and safety, not just slightly or maybe or possibly. So just because something doesn't work in the apartment or home doesn't mean that state law gives you a remedy. Now, you can look to your contract. If a contract says that something should be repaired or fixed, then look at that language, and if it doesn't require it to be health or safety, then obviously the contract itself gives you a right to have something fixed. The other place to look to with authority is a city code. Often city codes have certain requirements in it, and if the property doesn't have the things that are required by a city code, then you could even call a city health inspector or code inspector to have that problem fixed. So, let's say you've paid your rent, it is a problem affecting the health and safety of an ordinary tenant, and you've given notice, certified mail, and you've waited a reasonable time. What happens next? Obviously, try to work it out with the landlord. A landlord has a right to make the repair and has to make a diligent effort in doing so. If a landlord just puts some paint on a ceiling when there's a roof leak, that probably wouldn't be much of a diligent effort. But if a landlord does make a diligent effort to fix it, then there's no remedies under state law. Now, if the landlord doesn't, and you've done everything you're supposed to do, then you could take action in court. Filing suit in Justice of the Peace Court or JP Court is a place that you can get a quick remedy often to the problem. If you file an action in court, you could ask that the JP, the judge, order the property repaired, order the rent reduced from the time that you gave the first notice, even award you actual damages plus civil penalties for failing to exercise and perform their duty properly. That is one remedy that should be considered very strongly. There are other remedies available, like terminating your lease and moving out, or repairing the problem yourself and deducting the cost of that repair from your rent. But these two come with significant risks. Terminating your lease or repairing and deducting it yourself can get you in some trouble if you don't do it right. And even if you do it right, landlords very well may not agree that you have done so and give you problems, either on your credit report or even filing suit themselves for eviction if you've made a deduction from your rent that they don't agree with. So the better plan, and often the safest plan, is to consider filing suit in court. That does come with some risk, and that is retaliatory action. So you need to be prepared for that and recognize you need to be following the lease perfectly and paying your rent. If you do those two things, for sure, that minimizes the chance that a landlord will be able to retaliate. Otherwise, though, a tenant should very well try to get these things taken care of privately without filing suit if possible. But if not, that's what the courts are for.